Good afternoon, everyone, and welcome to the Fall 2021 Kansas Law Review Symposium. Thank you all for attending. We are very excited about discussing judicial conduct and misconduct with our distinguished panelists and authors. My name is Rachel Zierden, and I am the symposium editor this year for the Kansas Law Review. Today, our panelists will be discussing their upcoming articles that will be published in the symposium edition of the Kansas Law Review in the spring of 2022. Before we jump in though, let's discuss some preliminary matters. First and foremost, we will be recording the entire symposium for later audience viewing. If you wish to rewatch any part of the symposium, it will be posted on the KU Law YouTube page in a few days. Second, we have closed captioning available for all audience members. There is a button labeled CC that you can click to enable the subtitles. Third, we want you audience members to ask questions. On your screen, you will see an available Q&A button. If you would like to ask a question to our panelists, please submit your question through the Q&A chat. Please feel free to submit a question at any time during the presentation, but note that we will not be posing the questions to the panelists until the question and answer session at the end of the symposium. Questions will be visible to the audience when it is posed to the panelists. If you have any technological issues or problems seeing or hearing a panelist, you can also submit that feedback through the Q&A function. Lastly, we will be taking a 5-minute break before our keynote speech by Justice Caleb Stegall. So if you need to get up and move around, that would be the best time for it. Now that I've covered all of the preliminary matters, I will turn the virtual stage over to the Dean of the University of Kansas School of Law, Dean Stephen Mazza.
Good afternoon, everybody. It's my honor to open this year's Law Review Symposium. I want to start by thanking and recognizing Rachel Zierden, who is this year's Law Review Symposium editor. Rachel, along with Parker Bednasek, this year's editor-in-chief, and all the members of the Law Review have done a great job of organizing today's event. This year's Kansas Law Review Symposium, Judicial Conduct and Misconduct, a review of judicial behavior from sexting to discrimination, brings together a highly accomplished group of speakers. In addition to Professors Fortney, Davies, Arians, and Shepherd, we have two speakers with close ties to KU Law. Chris Joseph, a partner at the law firm of Joseph Hollander and Kraft, who is also a KU Law graduate, and today's keynote speaker, another KU Law graduate and Justice of the Kansas Supreme Court, Caleb Stegall. We organize symposium primarily to share knowledge and expertise about issues facing society and the legal profession, but we also organize them to support our students. So I want to take a moment and thank all of our speakers. During these difficult times, it would have been easy to decline to participate because of other obligations, but our speakers took time out of their valuable schedules to be with us today and support our students in our law school community. And on behalf of all of my faculty colleagues, I want to let you know how much we appreciate it. A special debt of gratitude is owed to distinguished Professor Michael Hoeflick, who worked with the students to put on today's program. So our thanks to Mike. And last but not least, I also want to thank Professors Laura Hines and Christer Hosel, who serve as the Law Review faculty advisors. They also support our students. And again, we appreciate that. Welcome to all of you who are watching via Zoom. I know we have many distinguished guests on today's Zoom call, including many jurists from around the country. Welcome to all of you. Thank you for being here. And without further ado, I will turn the program over to Professor Michael Hoeflick.
Thank you, Dean. Thank you, Rachel, and thank all of the Law Review. And indeed, I want to also thank specifically the speakers who've take an enormous amount of time and effort to do this under less than the most ideal conditions. I'm particularly happy because a couple of the speakers were my students once long ago. And it's always fun to have former students and current friends come back in these kinds of roles. And so I don't want to delay us further. I think we have an absolutely spectacular program ahead of us. And again, thanks everybody for coming here virtually. If you're not in Lawrence, I'll just let you know the weather is lovely outside, although actually I'm in Lecompton, not Lawrence. But Lawrence is a place where I hope those of you who have not been and couldn't come today will come eventually. And this is an every year occasion that the Law Review puts on these kinds of symposia, and they're always terrific. So again, thanks to everybody involved. And with that, Rachel, let me turn it back over to you so you can introduce the first of the speakers.
Excellent. Thank you, Professor Hoeflick and Dean Mazza. Now, as Professor Hoeflick mentioned, it's time to introduce our panelists. So first, we have Professor Ross Davies from Antonin Scalia Law School at George Mason University, discussing his speech, Impeachment by Any Other Name. Next, we have Professor Michael Arians from St. Mary's University School of Law, reviewing his paper on the appearance of appearances. Next, we have Professor Stephen Shepard from St. Mary's University School of Law, discussing justice and the rules, the moral obligations of magistracy versus canons, codes, and rules of judicial conduct. Fourth, we have Professor Susan Fortney from Texas A&M University School of Law, discussing taking courthouse discrimination seriously, the role of ethical leadership by judges. Then we have Mr. Christopher Joseph from Joseph Hollander and Kraft, LLC, discussing his topic, regulating the private lives of judges, where is the line? And lastly, our keynote speaker, Justice Caleb Stegall from the Kansas Supreme Court, will be discussing the ethics of decision-making, result-oriented judging, and the oven of Aknai. Please note that any PowerPoint presentation used by a panelist will also be posted for audience review after the symposium. With that, let's begin with our very first speaker, Professor Ross Davies.
Thank you, Rachel. It's a pleasure and an honor to be here. Hello to everyone, wherever you may be and whatever time it may be where you are. I am here to conduct just a short tour of some ways powerful people get rid of judges. This tour is focused in two ways. First, it focuses on the removal of judges from office, not removal of judges from particular cases. In other words, termination of service, not disqualification from a task. Because the focus of this symposium is institutional, on the relationship between judges and the offices they hold, not judges and their relationship to particular litigants or disputes. Second, it focuses on removal of justices from the US Supreme Court, not because there is anything special about them as judges, other than the extraordinary scope of their power, but rather because there is something special about their hold on their offices. They are the most secure in office of all American judges. No judge is more difficult to displace than a Supreme Court justice. And yet it has happened and can happen. Therefore, an examination of how those justices can be removed provides something of a starting point, a left-hand tail on the power curve of those who might seek to hold judges accountable for their behavior. This perspective is, in other words, a series of prompts in the form of observations of methods for removing extraordinarily well-positioned judges from office. Those methods of removal fall fairly neatly into three categories: incentives, coercions, and subversions. And while the most common forms of the first two methods, incentives and coercions, are generally unobjectionable, the third, subversions, is so objectionable that it should be abandoned and avoided. But before starting on this little tour of methods of judicial regulation, it must be said that the methods described here directly involve only three of the four most important participants in judicial regulation. Three categories of powerful people are or can be involved in the removal of Supreme Court justices: legislators, executives, and judges. A fourth category of people, fundamentally even more important than the other three, is not involved: the general voting populace. We, the people, are not directly involved in the removal of US Supreme Court justices, or for that matter, of any judges who hold office for life or some other term that insulates them from direct democracy. If I have time at the end of my talk, I will point out, though it will probably be obvious to everyone by the time I get there, that wherever voters have the power to remove judges via non-retention, non-reelection, or even recall, the uses of the subversions by other powerful people that I will be critiquing here are even more obviously inappropriate. Now back to the removal of Supreme Court justices from office via incentives, coercions, and subversions. First, the incentives. Supreme Court justices are not compelled to serve on the bench. They choose to do so. They are, in a very real sense, their own primary appointment authorities. And so, justly and with satisfying symmetry, they also have the power to remove themselves from office. So, all a legislator, executive, or other judge needs to do in order to remove a justice from the Supreme Court is to inspire that justice to remove themselves. Federal legislators can do this by using both carrots and sticks, both of which are, in some contexts, constitutionally sanctioned. For carrots, they can offer money and other perks to go away. In other words, rich retirement benefits. And this has been done. For example, it is one of the underappreciated aspects of what happened after President Franklin D. Roosevelt's court packing plan failed. Congress passed and the president signed legislation providing retirement benefits that were at the time so generous they might have been described as verging on interinstitutional bribery. For sticks, legislators can offer to make life miserable for a justice who refuses to go away. This too has been done. For example, the House of Representatives launched a pre-impeachment investigation in the mid-1960s of what some perceived as shady financial dealings by Justice Abe Fortas. Fortas resigned rather than run that gauntlet. The same maneuver failed, however, when tried on William O. Douglas twice. Once over his behavior during the Rosenberg spying controversy, and once over his behavior during the Vietnam War. The president, too, can use both carrots and sticks. For carrots, presidents can offer, for example, an appointment to a more attractive job for a particular justice. This approach was famously used by President Lyndon Johnson to remove a justice still in their prime in order to replace them with one of his favorites. He offered Justice Arthur Goldberg the United Nations ambassadorship, which Goldberg accepted. Note Goldberg's awesome arrogance. He believed he could influence LBJ and all world leaders to end the Vietnam conflict, after which LBJ would reappoint him to the court. He was, of course, disappointed, sadly, on both counts. Johnson then nominated, and after Senate and Vice and consent, commissioned his closest personal and presidential counselor, Abe Fortas, to the court. For sticks, Johnson, again, effectively disabled Justice Tom Clark from serving on the court by offering a great job not to Clark, but to Clark's son. When LBJ made Clark's son Ramsey Attorney General of the United States, Justice Clark was left with the choice of recusing in a vast number of cases at the court in which the US was a party, or retiring. He retired. He didn't have to, but he did. Another stick threatening prosecution of a justice might happen via an executive officer, a federal prosecutor, about which there were rumors with respect to Justice Fortas. And in theory, a state prosecutor could do the same. But note that such a maneuver might as easily inspire a justice to sit tight on the high ground of high office as to relinquish it under some sort of deal, which may explain why that has not been tried. Finally, justices themselves can also engage in a kind of incentivizing of a colleague to leave the court, sort of a combined carrot and stick peer pressure maneuver by informally urging a justice to resign. In other words, they approach a member of the club and say, the rest of the members don't want you in anymore, which has the potential to create discomfort if the person stays and perpetuate friendship if they go. There are a number of stories, some more sturdily documented than others, of efforts by the justices to press colleagues to resign or retire. Generally, this happens once there is a general feeling on the court that a colleague is losing their capacity to serve effectively. In 1865, Justice Stephen Field was deputized to approach the aging Justice John Catron about retiring. Field failed. Then a few decades later, young Justice John Marshall Harlan was deputized to approach an aging Justice Field. Again, failure. But then in the 20th century, this approach worked a couple of times when Chief Justice William Howard Taft approached a failing Justice Joseph McKenna, and when a failing Justice Oliver Wendell Holmes was approached by Chief Justice Hughes. Both McKenna and Holmes retired. McKenna a little bit less gracefully than Holmes. And this was also tried in the mid-1970s with an aging and failing Justice William O. Douglas, but that failed as well. The second category of methods for removal is coercions. This category is much simpler and briefer because there is really just one. And it is the US Senate can convict a justice of one or more high crimes or misdemeanors after impeachment in the House and a trial in the Senate. This has been tried once with the Supreme Court with Justice Samuel Chase in 1804, and it failed. But obviously it remains on the books, on the Constitution. It is there, and it has been used with other lower court judges. It must be said that experience with lower court judges teaches that other powerful people, namely the president via prosecutor and judges, and possibly in tandem with a jury, can also deeply influence impeachment via indictment, prosecution, and adjudication. True, it's not a technical loss of office. Former Judge Samuel Kent was convicted and did not give up the job until he was impeached or threatened with it. And indeed, acquittal after a trial can also trigger impeachment, as it did with former Judge Alcee Hastings. But that is not so much coercion standing alone as potentially a 100% batting average prompt to the coercive power of impeachment. Finally, it must be said with a cringe that there are other maneuvers to remove a judge from a court in a coercive way that are either utterly morally objectionable or at least extremely, in at least one case, extremely constitutionally questionable. In 1802, the Jeffersonians engaged in what amounted to reverse court packing by abolishing judicial offices that were occupied by sitting federal judges. But again, that was constitutionally questionable then and would still be now. Which brings us at last to the third category of judicial removal, and that is subversions. And here I am simultaneously sorry and pleased to say that I know of such an act. It's been well documented, but it is just one. And it involves other justices effectively removing a colleague from all judicial functions in what might be called the Douglas subversion, which sounds like the title of a Robert Ludlum novel, doesn't it? Justice William O. Douglas's colleagues on the Supreme Court secretly decided to hold over any case in which he would be the deciding vote. So the Douglas subversion, while not as violent as the subversion of justices in John Grisham's The Pelican Brief, was far more real. And here I must go into a bit more detail. On Friday, October 17th, 1975, 8 of the Supreme Court's 9 members, Chief Justice Warren Burger and Justices William Brennan, Potter Stewart, Byron White, Thurgood Marshall, Harry Blackmun, Lewis Powell, and William Rehnquist, met without telling the 9th member of the court, William O. Douglas, what they were doing. In a post-meeting letter hand-distributed only to the participants in that meeting, Justice White identified 2 decisions made by 7 members of that group of 8, implying that Justice White himself had dissented from those decisions. First, the quote, court would not assign the writing of any opinion to Mr. Justice Douglas, end quote. Second, quote, they would not hand down any judgment arrived at by a 5-4 vote where Mr. Justice Douglas is in the majority, end quote. They were motivated by concerns about Douglas's competence to serve. He had suffered a serious stroke the previous New Year's Eve, and his recovery was not going well. His disturbingly uneven behavior inside the court and in public showed that he was not well enough to at least consistently serve as a judge. For reasons about which we can only speculate, the group dealt with the problem in secret. The only direct evidence of this entire exercise is White's letter. According to White, the decisions of the 7-justice majority in the group of 8 amounted to arrogation by the court of the congressional power to impeach judges and remove judges. White was, as Professor Dennis Hutchinson describes him, quote, overwrought, unquote, by his own, quote, constitutional fastidiousness, unquote. After all, they had not removed Douglas from office. Instead, as Powell biographer John Jeffries explains, quote, they just took away his vote, end quote. This seems like quite the fine hair splitting here. In other words, when Douglas failed to recuse himself until he was capable of functioning effectively, the rest of the court took over and made that decision for him. The constitutionality of what amounts to collusive, compulsory, informal, secret removal via mass recusal functioning as removal is an open question. But the raw fact that the court has engaged in this form of self-management is not. Are there other possible subversions that the justices or presidents or members of Congress could engage in? Of course. Blackmail, extortion, kidnapping of justices' loved ones. I know of none of these, but just as with the Douglas subversion itself, members of a court that are willing to deceive both the public and other branches of government might do so again. So we do not know. I would like to think there is nothing there. In any event, we are running toward the end of my time, and I must get to what I hope are 2 thought-provoking questions that are prompted by these 3 categories, and in particular by the subversive but not necessarily destructive behavior of the majority of the justices on the Burger Court in the Douglas case. Other than the secretly slippery ethics of the Burger Court justice, there are at least 2 fundamental institutional questions that the Douglas subversion should inspire us to ask. First, there is the asymmetry, a disconnect between who put the justice on the court and who removed the justice from the court. In all the incentive methods, it is, in the end, the justice who made the decision to join the court and the justice who makes the decision to remove themselves from the court. And in all coercion cases, it is, in the end, the Senate that makes that choice. The Senate confirmed the justice to the court. The Senate, in effect, unconfirms the justice from the court. But in the Douglas subversion, it is colleagues who had nothing to do with his appointment. They have no particular allegiance to the reasons he was put on the court and no particular burden to bear by removing him from it. In other words, they are free to indulge in their own preferences, which are critically not the preferences of those responsible for putting people on the court, those who were elected to do that work. Second, there is the secrecy. Yes, it is worrisome as a moral matter, but what does it mean as a practical matter? How much else did and do Supreme Court justices do to regulate each other? Who knows? The fact that we do not know does not mean that they do nothing or that they do wrong. It also does not mean that whatever we might want to do to make things better or to aspire to make things better is necessarily better than whatever it is that they are doing in the shadows. One of the great challenges of regulating judges is how to inspire the people who have the power to put judges on the bench to take their responsibility as seriously and as intelligently as possible. In other words, to what extent and in what ways should choosing and removing be aligned? Conversely, the other great challenge is how to inspire people who end up with the power to remove judges to do right as well. In other words, we must ask not only how much we can trust the watchers to watch the watchers, but also how much the watchers really are doing, and can we really do any better? In the case of subversions, that is not a case where we may know as much as we need to. But again, what would be a better course? Thank you very much for your time and attention.
Thank you so much, Professor Davies, for that discussion on impeachment. We look forward to your article in the symposium edition. Our next speaker is Professor Michael Arians, discussing the appearance of appearances. Oh, and you're still on mute.
There we go. Thank you, Rachel, for the introduction. My article is titled, as Rachel said, The Appearance of Appearances. In February 2007, the Conference of Chief Justices issued a resolution in which they declined to support the upcoming edition of the Model Code of Judicial Conduct. For those of you who are not quite as well versed on the code, please note we'll start with the 1924 one, and then in fairly rapid succession in 1972, 1990, and 2007, the ABA drafted 3 different iterations of the Model Code of Judicial Conduct. In this 2007 edition, the ABA had put in Canon 1 as part of a larger Canon 1, the duty of judges to avoid not only impropriety, but the appearance of impropriety. The Conference of Chief Justices was unable to support this version of the Model Code of Judicial Conduct because it decided that not only should there be a canon informing judges to avoid the appearance of impropriety, there needed to be a rule, that is, a disciplinary rule found within Canon 1, which turns out to be Rule 1.2, as we'll see. And if they refused to do that, then the conference would not support the adoption of the 2007 version of the Model Code of Judicial Conduct. This got the ABA's attention. If the Conference of Chief Justices was unwilling to support the 2007 edition, the likelihood of successful adoption by states of the 2007 version went down dramatically. Less than 5 days later, the ABA voted on whether to adopt the Model Code of Judicial Conduct, and it decided it was going to do so, having changed Rule 1.2, as previously mentioned, by adding a rule that banned a judge from violating the appearance of impropriety, not just acts of impropriety themselves. So where does this appearance of impropriety come from? It has a relatively muddled background. You can find a couple of mentions in the early 1900s, 1904, 1910, where there is talk of avoidance by judges of the appearance of bias. It is a duty to remain impartial and not to favor one side as against another. This particular duty, as initially stated, was designed to deal with 2 particular problems. Problem 1 was the appearance of bias when judges, in this one case, appellate judges, who also did trial work, where they log rolled each other's decisions, affirming them on appeal. The critic of this said there is an appearance of bias that exists when Judge A approves of a decision made by Circuit Judge B as sitting as a trial judge on appeal, and Judge B does the same thing with regard to Judge A's trial decision that is also on appeal. So you had that one particular situation. Then you had the second situation, which was found in the Pennsylvania Bar Association's Special Committee on Legal Ethics. In 1905, the ABA, urged by a number, including the then President Theodore Roosevelt, decided to propose canons of ethics. And in 1908, the ABA adopted the canons of professional ethics. Those 1908 canons excluded intentionally and explicitly any canons with regard to judicial ethics. There was some effort initially by some members of the ABA to move on from the Code of Professional Ethics to a code or canons of judicial ethics. That was declined by the ABA Executive Committee, its powerful body at that time, in large part because the ABA was concerned that this would give more fuel to the progressive fire regarding the recall, impeachment, and otherwise removal of judges across the country. However, the Pennsylvania State Bar Association, when looking at the ABA's canons of professional ethics, thought that they simply didn't do a very good job. So the special committee came up with 102 rules of ethics. the last 13 of which had to do with judicial ethics. Those 13 rules included as one rule the avoidance of the appearance of bias, but only in a particular instance. When counsel were arguing, a judge was certainly permitted to ask questions of counsel, but the judge, under this proposed rule, was supposed to do so without showing any appearance of bias. In addition to those two specific rules, there was a more general assessment by a guy named Charles A. Boston, who will become a major player in our story. Boston was devoted to the issue of ethics, in particular the issue of judicial and professional ethics. He'd written a lot on the canons of professional ethics as they went in their formative stage and even after they were approved. He then became a powerful figure in the New York County Lawyers Association. He created the system of opinions by bar association with regard to what constituted professional conduct and professional misconduct. And in 2011, even though it is unstated, apparently following up on Roscoe Pound's 1906 speech to the ABA, the causes of popular dissatisfaction with the administration of justice. Boston and his co-author sent out a brief questionnaire to a number of lawyers across the country and asked them, are you and the public of which you are a part satisfied or dissatisfied with the administration of the law? They published their results in the American Law Review in 1911. In this relatively lengthy, for that period of time, article, near the end, the authors came up with the idea that judges should avoid not only improper influences, but the appearance of corrupt or improper influence. The following year, Boston spoke to the annual meeting of the ABA, largely about lawyers and the high ideals that the legal profession ought to aspire to. Near the end, he threw in a little bit about judges and once again mentioned that there should be an avoidance by judges of an appearance of bias. Despite these efforts by Boston, and even despite the creation of the American Judicature Society in 1913, relatively little happened after that with regard to what standard of conduct did we wish judges to have. Yes, we want them to be impartial, but do we also want them to avoid the appearance of partiality, the appearance of bias, the appearance of impropriety? And then came the Black Sox Scandal. In 1919, the Chicago White Sox were the heavy favorites in the World Series. And as any of you who have either read the book or seen now the relatively old movie, 8 Men Out, remember, there were 8 members of the Chicago White Sox, including the most famous shoeless Joe Jackson, who were accused credibly of throwing the World Series by acting or by playing not to their full capacities. As a result, there was great fear that the game of baseball, if viewed as subject to fixing by gamblers and players, was at a crisis point. The response of the owners of the teams from the National and American Leagues was to hire someone who would clean this all up. The person they turned to was a man named Kennesaw Mountain Landis. Landis was a federal judge in Chicago. He was possibly not the most well-regarded judge in Chicago, though he did have his fans. And the owners of baseball offered him the extraordinary sum of $50,000 in salary per year to take on this position, which Landis himself eventually called commissioner. Landis declined the $50,000 offer, but counteroffered by saying, if you make my pay $42,500, I'm already paid $7,500 as a federal judge. That gets me to $50,000. Then if you throw in $7,500 worth of benefits and expense money, I'm your man. And they decided to do so. This rankled some Chicago lawyers. This rankled the ABA. This rankled at least some members of Congress, most of which were fruitless. The ABA did eventually censure Landis, the only person it ever gave that, how shall I say, the only person who ever received such a statement from the ABA during its first half century of existence, which bothered Landis not at all. But the Landis censure was the trigger for Charles Boston to again try to move toward a code of or canons of judicial ethics. He suggested to the ABA Executive Committee that they create a committee, and in early 1922, it did. It consisted of Chief Justice William Howard Taft as its chairman, two Supreme Court Chief Justices, one from Pennsylvania, one from Maine, and Boston as secretary, and then Senator or former Senator George Sutherland, who eventually was replaced by two separate men successively who had relatively little to play, role to play after Sutherland was named to the Supreme Court. So he had 3 judges and 2 practicing lawyers. All of the work, well, the vast majority of the work was placed on Boston. He crafted the initial canons of ethics, the first version of which comes out in June 1922 among members. And at that time, he includes as one of the early canons, then not numbered, that judges should avoid the suspicion of impropriety. By the time we get to the second revised edition of the Canons of Judicial Ethics in January 1923, the title of that canon has been changed to what it becomes its title in 1924, Avoiding impropriety and the appearance of impropriety. Once he did so, the other judges, while they had other issues to deal with, largely left that canon alone. When finally adopted in 1924, about which I'll say more with regard to its adoption in the paper, that canon, the appearance of impropriety, was not only part of what was then Canon 4, but sprinkled throughout a number of the other canons of judicial ethics. And then largely nothing. Very few decisions of courts, very few law review or other articles speak of what do we mean by this appearance of impropriety. For Boston, it was clear. The appearance of impropriety was really about the idea of honor. And the idea of honor is, what is your status? How do people view you? It's not an internal notion. It's an external notion. And what Boston was trying to get across to judges was, you should look to be approved by the people and by your peers, that is, the lawyers who go before you and others within your community. So you had a couple of cases that would talk about the appearance of impropriety, but largely very little happened. And as Ross just talked about, the issues with regard to Abe Fortas and then Clement Hainsworth in terms of their ethical improprieties, at least as perceived by some, led to a revival and thus the creation of the 1972 Code of Judicial Conduct. That code actually said that, actually kept the same standard, only now this standard was going to be a more disciplinary-like standard. The 1990 version decided to go even one small step further and make it not disciplinary-like, but to ensure that standards of discipline could be applied to those justices who avoided or who engaged in violation of the appearance of impropriety standard. By the time we got to 2007, the commission that was looking at the Code of Judicial Conduct was trying to figure out, does it make sense to still have a rule that can be used to discipline a judge for engaging in something that is considered an appearance of impropriety? And there was division. The majority, as reported by the ABA, said we ought to keep this standard as a rule. And as we began, that's what the Conference of Chief Justices wanted. So within a week, after getting the resolution from the Conference of Chief Justices, the ABA changed its mind, amended Rule 1.2, and kept, as was previously the case, the standard of appearance of impropriety, not simply impropriety. And how has that worked out in the 15 or so years that we've had? Well, we can confidently say that it's worked out well for those who want to discipline judges for violating an appearance of impropriety. We're almost at 100 cases where that standard is used. And what that gives you, or what that causes one to think or consider, is the appearance of impropriety itself a standard, or is it simply a catch-all, much like conspiracy statutes in the criminal law that allow you to catch all people who may or may not have been heavily involved in a particular crime that's been committed? In general, it appears that the Conference of Chief Justices prefers the appearance of impropriety standard because it can use it as a secondary tool to show how its decision to discipline a judge is actually justified. Thank you very much.
Thank you, Professor. That was excellent. Thank you for discussing the appearance of impropriety, and we're really looking forward to your article. Okay, moving to our next speaker, we will have Professor Stephen Shepard regarding justice and the rules, the moral obligations of the magistrate versus canons, codes, and rules of judicial conduct. Professor Shepard?
Well, hello. I am very pleased to be here. I'm going to take just a moment because having been taught by my students how to use a lot of this technology, but only having been taught little bits and pieces of it according to their preferences and needs, I could be a tad slow. Now, I don't know if you're able to see this. So can you tell me if you can, since I can no longer see you, Ms. Irden?
Yes, we can see it.
Beautiful.
Thank you very much.
All right. And do you see the little pictures up here? Or can you do you just see the white screen with the black letters?
We just see the white screen with the black letters.
Beautiful. That means that I get to see you, and you don't have to worry about looking at me, and you don't have to wonder about how I managed to broadcast from the middle of a room that Mike Hoeflick and Ross and a few others will recognize as Duke Humphrey's library. So let me first note that I am not going to walk you through the entire article, but I'm going to try and stay within the remaining 14 minutes or so, because I think that's what we're expected. And I want then to thank not only my fellow Stephen, Dean Maza, Mike Hoeflick, in whose honor this work is being put forward, and of course, Ms. Zierden and her team for the tremendous efforts that you've put into what is obviously an assemblage of very, very thoughtful and remarkably coherent people who seem to be pursuing ideas regarding the ideal of justice in the judging, or at least the best ethics in judges in a remarkably consonant manner. And so thank you all very much for all your effort. So this word I put up front in the article is justice. It's a word that, especially in the last 50 years, has not been highly regarded by institutionalists, not by most lawyers, not by most law professors, certainly, and indeed, especially not by the people that seem to be its keepers, the legal philosophers. And there are a variety of reasons for this. It is not always true that Americans don't think justice is a part of law. There are many people today who argue for justice, and not only in the public, but also in the courtroom. And yet the lawyers, judges, and many others who hear these arguments are highly skeptical. And I think that most historians would agree that There are lots of reasons for that, largely born in history because of the conflicts that we're all too familiar with, in which both sides claim the right, whether it is because they believe that they're divinely guided or that justice is some sort of ethereal spirit is on their side. And these include not only both sides of the Civil War, but following the war, the holy segregationists, and basically the whole nature of religious wars, whether they were the English Civil War pitting relatively similar Protestants to relatively similar Protestants, the religious wars of Europe, which were sometimes between Ottomans or, for that matter, Spanish Muslims and Christians, or, as was more often the case, simply among different strains of Christians. It can be very difficult to believe that anybody can do something useful with an argument of justice when the arguments of justice so patently lead to conflict. And indeed, one of the catchphrases of the last 30 years in the world of philosophy concerning the nature of justice is that justice is controversy. There's probably no more often quoted role to dismiss justice from the law than to quote the title of the first article written by H.L.A. Hart, The Separation of Law and Morals. It's true that Professor Hart says in not only that article, but in his 1960 book on the concept of law, and many times thereafter, law is not the same as morals. But you will scour all of his writings in vain to find any place, he says, that law does not have a need for morals. And having distinguished morals from law, he then is in a position to be able to say there is a role that morality does play, and it is rather important in the law, and I'm going to come back to this. So in order to understand, I think, the strength of the argument for justice, you have to understand a little bit about what is law, and that also is a place where there's a great deal of argument, but I think it'll be easiest if we take a few of the most influential arguments for law of the last 100 years. First, let's take Herbert Hart's approach. His book argues, I think very well, that the two dominant views of law work fairly well together, taking one type of rule, that is to say all the constitutional and administrative rules, the rules by which we make laws, we apply laws, we change laws. Those, he says, are secondary rules. And there are also primary rules, the rules that govern what we do in ordinary conduct, the rules including making more rules for ourselves like contract, but the rules of tort and crime, the rules of property, the rules of environmental regulation, all these things are primary rules. And so the law is the union, a system of secondary and primary rules so that we can make the rules and we can apply the rules. That's how law works. Mature legal systems have these things. As much as I admire Herbert Hart, as much as I admire his writings and as influential as they are, that model is, I think, as incomplete as he found the models of the positivists that he was critiquing. And taking an argument by Robert Covert that came about a decade and a half after Hart's, he wrote this very influential article, Nomos and Narrative, in which he says that the rule and the discussion of the rule are both important to understanding the rule. And he applied this very broadly to describe how law works. And he had an elegance that I can never aspire to. And so what I've done is say, if we take these three things, if we take them from an American perspective that is fairly well anchored to the pragmatic Oliver Holmes, who says what the law is what the law does. Well, that's probably right. And yet this is also the same Oliver Wendell Holmes, often ignored by his critics, who admonishes law students in the very same speech he gives that to ensure that they have read their theory and their history and they know the rules of the law into the last jot. So what do? Combining them, we have the idea that the rules for making and administering the law and for requiring, prohibiting, or allowing ordinary conduct that are synthesized from the archive of all past legal statements and actions by the current profession according to its present custom. That's the law. You cannot understand law without understanding that it is performed, that it is done. It is something that happens right now, and it is recorded as it's performed, and those recordings become the new archive. That as we act, we change the law. This is a Kelsenian idea, that whenever you change anything in the law, you change its foundation. Well, that's right, but it's even worse than that. The customs we have now are very much more important in the law in many ways than the archive, though the archive as the source of those rules is more important than what we do. So if that's what the law is, then we have some challenges. The most important one is, if that's all the law is, what keeps us from having the laws of the Third Reich? What keeps us from having Jim Crow? What keeps us from disenfranchising the people that we disagree with or that we fear? Well, if that's all there is to law, nothing. And Hart is right. There is nothing in the law made by human beings that cannot be changed by human beings to accomplish those ends. It's precisely those illustrations he had in mind that made him very, very concerned that people thought somehow the law could prevent being corrupted until it fails. And this is why in the very same book, in a remarkably overlooked passage, he takes pains to describe the pathology of law. Law that is so untrustworthy, law that is not pursuing the right ends as those are understood in a culture or by a people, will lose the trust and confidence and the compliance of the people, and it will lose the faith of officials and their best efforts, and the legal system dies, as it did in Germany, as it basically had in many ways in the southern United States, not just before the American Civil War, but very nearly in the 1960s and 70s. So people fight, people argue, and as a result, there is nothing the law is doing around which they can completely agree and even partly agree. So where in all that is justice? Well, among other things, justice has been around for quite a long time. The earliest written indication I have of a conscious idea of justice seems to be in these Akkadian statements by Inanna and Sukalatuda that are about 4,000 to 5,000 years old. That the greatest power among the divine has an obligation and is performing the obligations by detecting falsehood and determining justice to identify the criminal against the just, and that is why she goes to the mountains to observe. Antef, one of the great leaders of what we would now think of as the Sumerian Empire, had engraved on his grave stele, "I am a man of justice, like the scales of justice impartial." Most of us know Cicero's very famous maxim that the health of the people, the welfare of the people, what is good for the people is the highest law. And I didn't bother inserting these quotes for lack of time, but most of you know of the Golden Rule, adapted by Jesus of Nazareth from the teachings of Hillel, the great reforming rabbi, and the idea of Sir Edward Coke of natural reason. All these are floating around. So how do we synthesize them? Synthesize them. And I think the answer is one that I redacted in some ways from a series of statements made by Congresswoman Barbara Jordan from Texas, who said, "You all keep saying it's very hard to do justice so that everyone disagrees. Justice isn't hard. You just don't want to do it." This is something she was saying to both her colleagues and her party members. Well, if that's the case, then at least we need to look at some components about what it is that we would do. And I think we could break it down as with laws, justice, given that it arises in a similar manner and has to be dispensed in a similar manner, although perhaps with some differences, has the three same components we're used to in law. What is the duty of someone who must be just? What is that person doing to perform it? And what are the consequences of doing it or not doing it? Now, this is much too lengthy to go into in the remaining couple of minutes, but I have spent a number of years combing the tremendous oeuvre of writings about justice in a variety of cultures and a variety of eras. And I've synthesized about 2,000 different references into 23 questions. And I've put them for this purpose in a manner that might look a little bit like the rules and the canons of justice. What is it that I ought to do? How do I know that I'm doing what I ought to do? Am I allowed to take this money in a campaign? Am I allowed to prefer this person because of what they did? I certainly hope not. It boils down to a series of requirements, or if you prefer, a series of virtues. And as I say, I'm not going to go through all of them, but I am going to point out a few. The most important, I think, are that we have to understand that whether we act or fail to act is what guides whether justice can be done or cannot be done. And how we do it is as important sometimes as what we do, but the result is essential to understanding what justice is. And it can boil down to the following 3 or 4 statements, depending upon how you divide them. Justice is what the law ought to do. It is a reasonable and objective sense of what will make the greatest peace among all the parties if everything is known over the fullness of time. And lastly, it is a part and parcel of trying to do the least injustice, recognizing the law has many improbable choices. These compare very, very distinctly with the rules. They provide for a substance, they provide for omissions, and most importantly, they require change and changes in order to cure past injustices and in order to evade injustices in the future. And that I will leave you with. If we get it wrong, the result for the legal system can be almost intolerable. This is a quote from Herodotus. And Ms. Zierden, I see you very discreetly in the screen, which is my indication my time is up. And I thank you all very much.
Thank you so much, Professor. We enjoyed your conversation regarding justice, and we look forward to your article as well. With that being said, let's move on to our next speaker. We have Professor Susan Fortney discussing taking courthouse discrimination seriously, the role of ethical leadership by judges.
Good day. What interesting questions. Well, thanks to Rachel Zierden, the Law Review members, and Professor Hoeflick for including me in this worthwhile symposium. I very much welcome the invitation to participate because I've been thinking about a particular judicial ethics topic for a few years since the time that we conducted an Inn of Court program, which we call the Ethics of Diversity. And I was the chair of that planning program, that planning committee for the Inn of Court. And what we did was to develop a number of interactive scenarios. And one of the judges who was also on the planning committee thought that we should include one involving discrimination at the courthouse. And rather than it being some kind of bias or discrimination on the part of the judge, him or herself, the twist that we wanted to include was that the misconduct was by some other court personnel. And basically what we did then with that scenario is that we considered the reach of the anti-bias rule in that particular jurisdiction, as well as the judge's responsibility. And it was with respect to a bailiff who was refusing to call a transgender litigant by her legal name, and the judge knew about it. So basically what we wanted to do is to get the people in the Inn of Court to really think about that. So that was a couple of years ago. And since that time, what we got in terms of the national news were the reports related to the then Judge Alex Kaczynski, a very high-profile Ninth Circuit judge, as many of you probably know, was accused of sexual misconduct. And shortly after those news reports, Chief Justice John Roberts asked the director of the Administrative Office of the U.S. Courts to establish a working group to examine safeguards to deal with inappropriate conduct in the federal judicial workplace. And KU actually has a connection to the working group, as Chief Judge Julie Robinson of the U.S. District Court for the Kansas District and a KU grad was a member of that working group. And that working group spent a period of time in in-depth study. They got all sorts of input, and after deliberation, they issued a comprehensive report. And based on the recommendations made in that working group report, the Judicial Conference for the U.S. approved a number of reforms related to workplace misconduct in the judiciary. And those reforms included revising the Code of Judicial Conduct for U.S. judges, as well as procedural and programmatic changes intended to help the federal judiciary both prevent and address misconduct in the workplace. And what I'm doing for my piece for the KU Symposium is to draw on the findings from that working group report and consider the lessons for state judiciaries. And in reading that working group report, I think what was most noteworthy was the way that it approached the responsibilities of judges and what I characterize as ethical leadership. And in particular, I think what we see is the changes that came out of that report included changes to the code that I previously mentioned. So what I have on the screen is the revised code provision. And you see that it now expressly states that a judge should practice civility by being patient, dignified, respectful, and courteous. And basically it goes on, but the part I want to call to your attention is the last portion that says a judge should hold court personnel under the judge's direction to similar standards. So what we get following the actual canon are comments, and putting together the rule and the comments, you see that it is clarifying that a judge should neither engage in nor tolerate workplace conduct that could be reasonably interpreted as harassment, abusive behavior, or retaliation for reporting such conduct. And basically, under these provisions, judges shouldn't turn a blind eye. That's what it was called in the report. Should not turn a blind eye to others' misconduct, but should accept responsibilities as what I call captains of the ship, who lead by example, setting expectations, and holding judiciary employees accountable for misconduct. So that's on the federal side. And similarly, I think that state codes of judicial conduct should expressly cover judges' supervisory responsibilities. If you look at the ABA code provision, this is the ABA model judicial code provision, Rule 2.3b, you see that it first sets out basically the anti-bias discrimination provision to include harassment. But it also, at the last portion of this rule, states that the judge shall not permit court staff, court officials, or others subject to the judge's direction and control to do so, to engage in this misconduct. So the ABA model judicial code also captures the supervisory responsibility. But if you do a survey of the codes around the country, you'll see that there are 3 jurisdictions that have no anti-bias code, and that a number of the jurisdictions that have an anti-bias code don't have the provision that expressly deals with the judge's responsibility when the judge knows about misconduct by court personnel. And so I think for the reasons set forth in that working group report, I think Supreme Courts in those jurisdictions should amend their codes and to expressly deal with the judge's responsibility to not only refrain from engaging in any kind of misconduct that's described, but also to take action when they're aware of misconduct by others with whom they worked. Kansas actually has the rule identical to the ABA rule. So that's one piece in terms of these other jurisdictions that don't have the provisions in the ABA rule. But even in those jurisdictions that have a version of the ABA rule, what we see is very little, I think, decisions that apply the the rule in a way to actually discipline judges. Now, when you think about it, when it comes to decisions related to judicial conduct, it's hard to find many of them necessarily in a traditional Westlaw or Lexis search. So instead, what we've done is gone into the websites and various databases for the state judicial commissions. And that has not revealed much. And so though we haven't really yielded results from that kind of search, I have found one case, for example, coming out of North Carolina. So I found a disciplinary matter that was reported in the Judicial Conduct Reporter that's published by the Center for Judicial Ethics at the National Center for State Courts. And it was a decision in a 2020 case. And in that particular matter, the North Carolina Supreme Court adopted the findings of the Judicial Standards Commission in that state, concluding that a Court of Appeals judge had committed misconduct by allowing his executive assistant and law clerk, who was a personal friend, a close personal friend of the judge, to create what was characterized as a toxic environment for others. And after going through the findings of fact, that the court rejected the arguments of the judge that the judge could only be sanctioned for the judge's own actions. Instead, the North Carolina Supreme Court indicated and interpreted the Code of Judicial Conduct in that state to require judges basically to deal with court personnel, because the code talked about judges' responsibility to require dignified and courteous behavior on the part of the staff. And the court again used that same expression in saying that the judge continue to turn a blind eye and fail to take corrective action, and that for that reason, the judge was disciplined. And I'm thinking about just recent events, whether it be the Me Too movement or what is called the Us Too movement coming out of an International Bar Association report related to sexual harassment in the legal profession. And if you put those together with developments following the working group report, I wonder if we're going to start seeing more complaints involving judges' failure to address bias and discriminatory conduct by court personnel. I think there are a few explanations why you don't find opinions. Or decisions, should I say. First, I think the most positive is the judges are doing their jobs and they're dealing with the issues, and therefore we don't see any complaints alleging misconduct for failure to discharge that supervisory duty. So that's the most positive. I think more pessimistic possibility is that this whole concern of supervisory responsibility is somewhat of a dead letter. It's on the books, but nobody's really paying attention to it. I think that another explanation is that there is reluctance generally on the part of lawyers and other court personnel to report misconduct by judges or those who work under the judge's direction and control. And this is what the working group, that federal working group, again noted was the most significant challenge to accountability. It is the reluctance of victims to report misconduct. As explained in that working group report, victims are hesitant to report harassment and other inappropriate behavior for a number of reasons, including the lack of confidence that they will be believed, that the fear that action won't be taken, and concerns about retaliation and the effect of on future job prospects. You can think of it as law students. going into a clerkship, and how difficult it might be to being in a clerkship and reporting misconduct on the part of a judge. And that, again, was part of that impetus in terms of the working group and the reforms that followed. And so what the working group report did was to try to consider those barriers and suggest ways of addressing them. And also it provided a discussion of alternatives to traditional complaint process. But what I'm suggesting, and will develop in my piece, is that state judiciaries should really accept that call to action and consider some reforms. And there's some very simple ones that state judiciaries can take. And one of them is to allow for anonymous reporting of judicial misconduct. A survey of procedural rules relating to judicial ethics complaints reveals that many states do expressly allow for anonymous complaints that obviously would have to be substantiated, but they do allow for anonymous states. Another number of states don't allow for anonymous complaints to be filed. Rather, they require that the complainant sign their name or be verified, notarized. And even if a state, let's say Judicial Commission, relaxes the rules and opens investigations on their own, I think there is value to still allowing for that anonymous reporting to actually be set forth on the website so that a prospective complainant knows that they can file something on an anonymous basis. So basically, there are concerns that some may have related to anonymous reporting, but basically the Center for Judicial Conduct says that those are largely misplaced. But in addition to these procedural changes and changes in the code themselves, I think more than anything, I'm hopeful that state judiciaries will really look at this in a more holistic way, and in particular, examine the role of judges, again, as ethical leaders in what is called their ethical infrastructure. And some of you know that the whole concept, the term ethical infrastructure, was coined by Ted Schneer from Arizona, and it was this thought that ethical infrastructure refers to the policies and procedures within an organization. But in a study, a National Science Foundation study that I'm conducting related to sexual harassment, we're using a more inclusive connotation of ethical infrastructure to go beyond policies and procedures, but to include informal influences and climate. Because what we've learned in this area is that climate and culture are the most important determinants in terms of sexual misconduct occurring and not being addressed. And so I'm hopeful that what will come out of this working group report and the examination of these particular issues is for decision makers to look at this concern of what is the ethical infrastructure of our organization, not only what are our policies and procedures, which are considered the minimum, the floor, but what are those informal messages that we're sending? Are we clearly communicating that bias, discrimination, harassment will not be tolerated? And so most importantly, I'm hopeful that judges will consider their role as ethical leaders and recognize that they can play an instrumental role in maintaining the integrity of the judicial process and cultivating a healthy work environment where all can work and thrive and litigants can come and do so knowing that they will be treated fairly. And so during the discussion later today or afterwards, after the symposium, I welcome your thoughts, your observations related to facilitating reporting and more generally the steps that judiciaries can take to demonstrate their commitment to accountability. Thanks again for the time.
Thank you again, Professor Fortney. That was excellent. It was interesting learning about ethical leadership in the state courts, and I look forward to a further discussion in our question and answer session. All right, so let's move on to our next speaker, Mr. Christopher Joseph, discussing his topic, regulating the private lives of judges. Where is the line?
Good afternoon. I am a practicing attorney in Kansas. I'm going to try to start this screen share. Here we go. I represent, part of my practice includes representing judges and attorneys who have ethics concerns or are brought up in disciplinary proceedings. And let's see if I can get this thing going. Yeah, terrible at the PowerPoint. Hopefully you can see the screen. It's not in presentation mode right now, but anyway, I represent judges routinely before the Judicial Commission on Judicial Conduct, and I've been asked to talk about a number of things related to that proceeding or that process. I wrote, or I'm going to write, on regulating the private lives of judges, how you do that, where the line is, because in that practice of representing judges, it's been surprisingly focused on conduct outside of the courtroom. In other words, most of the complaints and most of the evidence and testimony really isn't about things that happen in the courtroom or even in chambers or at the courthouse. A great deal of the complaints about judges that are initiated relates to conduct outside of the courthouse, conduct in their personal lives, some of which may be subject to regulation appropriately, some of which maybe isn't subject to regulation appropriately. There's various categories of conduct, and there's various options for where you draw a line, if you draw a line, for regulating the private lives of judges. That is the intent for my article, for what I'm going to write on. However, because I'm a practicing judge or a practicing attorney, I am subject to scheduling by the Kansas Supreme Court, and I have a case right now that is submitted before our keynote speaker that touches upon that very topic. And because of that, it seems rather inappropriate to talk about my advocacy for that client and our positions while our keynote speaker is going to be present and addressing the same. So as a result, I've talked to Professor Hoeflick, and we have switched up. Instead of talking about regulating private lives, which I may end up writing about, I want to talk about representing judges just generically in judicial conduct cases, the process and how it works as a practical matter, just kind of a general overview. Initially, we have a Commission for Judicial Conduct in Kansas. It's formed with a number of members, some of which are judges, some of which are practicing attorneys, and there are community members. There are two panels. There's panel A and panel B. One panel serves as the investigative panel that looks in to find out whether there's probable cause or not. The other panel prosecutes or hears a case that is prosecuted against a judge. It's a very general and broad overview, and this is consistent really across all states, just from the canons. The purpose is to determine whether or not a judge is acting ethically, whether or not they are impartial and independent and competent. There are a number of key words. I talk a lot about integrity, what it means to regulate integrity, what part of a judge's life is looked at. All of those issues are presented and in a formal complaint that we'll get to in a moment. The commission in Kansas has somebody called the examiner, who is appointed by the Supreme Court. It represents the examiner's position, functions before the investigative panel as essentially an investigator that goes and interviews witnesses and reports to the inquiry panel. The inquiry panel then determines whether or not there's probable cause. If there is probable cause, it's sent on to the panel that forms the hearing panel, and the examiner then takes off the hat of an investigator and puts on the hat of a prosecutor, essentially like a criminal prosecutor or an advocate for discipline. How it all starts is a complaint can be filed by really anyone. There's no limitation. This is from online. A complaint against a judge is the form. You can go online, you can fill it out. Anybody can fill it out. I don't have any statistics, and I don't know that they keep them in terms of the number of complaints that are filed, in terms of whether or not they make it to a probable cause finding or not. But I imagine it's similar to what you have in attorney discipline. And in attorney discipline, there are a whole lot of complaints that are made where there is not a probable cause finding and where it does not end up going to formal hearing. So anybody can fill out a complaint. It then gets assigned to one of the panels, the investigative panel, and the examiner investigates. When that starts, the panel that is assigned asks the judge for a response. You get a copy of the complaint. And this is very similar to an attorney discipline complaint where the judge or the attorney gets to make a response. This is a copy of a letter, an actual letter submitted to one of my judge clients. And this is where I will take a little bit of a position. If you read this, it simply is, hey, there's been a complaint. Why don't you go ahead and give us your version of events? The Supreme Court wants to know what happened. When you go and hear from the disciplinary folks for attorneys, when you hear CLE presentations, when a complaint is made against an attorney gets, at least in Kansas, it's the dreaded gray letter from the disciplinary administrator. It says, you have a complaint. Attorneys are taught, whoa, wait, stop. Don't respond on your own. Go seek advice from a colleague. Go hire an attorney. Don't represent yourself. Make sure that your response is adequate. With judges, the way it's captioned is, the way it is written is almost such that I've never seen a judge seek counsel at this stage. Generally, it's just, hey, it's a much more friendly approach, but judges probably should treat it just the same as if it were a complaint against an attorney and seek some independent advice. I've seen some rambling responses because, again, the lawyer who represents him or herself probably shouldn't. So it goes to the inquiry panel with a complaint, the judge's response, and then also.
Hello? Hey, what you up to?
And also anything that the examiner has found. The inquiry panel can find a violation. They can issue a letter of caution or cease and desist, or they can send it to the Supreme Court for a formal, or refer the matter to the hearing panel for a formal hearing. So the next document that comes out is a notice of formal complaint. This again is another example from one of my cases. It is where I get the call. Suddenly a judge is quite flustered that there has been a formal complaint filed. They figured the response would be sufficient. It wasn't. The inquiry panel found probable cause, and here we are. Now there's a formal complaint and a hearing. The key is that once this document is filed, there is no way to unwind this short of a full formal hearing, oftentimes with evidence. And that really blows the minds of the judicial clients that I have, which is why I urge everyone when they get the initial, hey, here's a complaint been made, to seek counsel, because that's the only chance you have to derail things is before the inquiry panel to find that there's no probable cause. Because when it gets here, you're going to hearing. The formal hearing is an evidentiary hearing. I had a 3-day hearing not too long ago, a year or two ago, before the pandemic. Rules of evidence apply, but at the end of the evidence, the panel can decide whether or not to admonish the judge, issue a cease and desist, or refer it to the Supreme Court for discipline, at which point it goes in front of our keynote speaker for a disposition. And it's just like every oral argument before the Supreme Court. You can brief and you can make argument. The briefing's a little bit different. They're called exceptions instead of an opening brief where you challenge findings by the panel, and then you go and present your argument. The argument can be very fact-based, or it can be more academic, such as where the line should be drawn in regulating the private lives of judges or any other topic. The justices then can generally, they can do anything. Anything's in the rule where they can reject the panel's recommendation, find no violation. They can find that there was a violation and discipline. Discipline can come in the format of a number of things. It can be a written admonition. You can also, they can actually throw the judge out of office with compulsory retirement, or they can issue an order requiring, well, essentially a cease and desist order. So the last topic, and this again is a rather brief overview, confidentiality. This is something very few folks worry about until you're in front of a disciplinary proceeding or involved in a disciplinary proceeding. Very interestingly, early on, as early as the formal complaint, if there is probable cause found and a formal complaint is filed, the formal complaint is public. Anything that goes in front of the hearing panel is public, and the news can grab onto those documents, the formal complaint, the answer you filed, evidence exhibits before the hearing panel. I've had the Associated Press sit in on argument and evidence before, and judges are often quite surprised to find out that even just on a probable cause finding, the formal complaint can splash in the headlines. So that is a quick overview of the process. It is a practical thing. It is like any other trial or hearing. Judges who get a complaint, the thing that I would ask them to consider is hiring early or getting at least a colleague or friend to review a response so that it's not just kind of a rambling, here's what I think is sufficient, because it's impossible to represent yourself and be objective. Hopefully I'll write a little bit on the academic side later, but at the moment, that's all I got.
Thank you so much, Mr. Joseph, for that discussion on the judicial conduct proceedings. And we look forward to discussing regulating the private lives of judges after that case has been decided. So in the meantime, we are going to go ahead and take a 5-minute break. We will be back shortly for our keynote speaker, Justice Stegall. All right, everyone, thank you so much for the break and welcome back to the Kansas Law Review Symposium. Up next, we will have our keynote speaker, Justice Caleb Stegall from the Kansas Supreme Court, discussing the ethics of decision-making, result-oriented judging, and the oven of Acme. All right, Justice Stegall.
Good afternoon, everyone. I'm sorry you had to see me roll my chair and shut my door there. That's one of the perils of Zoom, I guess, but it's a real pleasure to be here as part of this symposium. Certainly thank you to Rachel and Mike and Dean Mazza and my fellow panelists. It's been a good afternoon so far, and I trust that it's been valuable for all of you who are listening. That said, I have to confess that as a judge, it does feel a little bit dangerous to walk into a room full of lawyers who have been primed by an entire afternoon of thinking about judicial misconduct. So I will do my best to be on good behavior. So as I confronted this topic, I did what I often do, which is whenever I am confronted with a problem, the first question I always ask myself is why? So here, why judicial ethics? What purpose is even a conference like this actually serving? And the most common rationale given for the existence of judicial codes is that they're necessary, in the words of, I'll quote the preamble to the Kansas Code of Judicial Conduct, that these codes are necessary to maintain and enhance confidence in the legal system and to ensure the greatest possible public confidence in our judges' independence, impartiality, integrity, and competence. And this is no doubt true, because we know that a corrupt, a wicked, or an incompetent judiciary is one of the surest paths to a lawless society. Now, that being said, it does seem to me, or at least it seemed at the outset of thinking about this, that given that this is the stated purpose of judicial codes, ethic codes, there's something big missing from our narrow understanding of judicial ethics as represented by our codes of conduct. Indeed, a realistic assessment of the public's confidence in judges and their judgments really does suggest that the quality of judicial decision-making itself is the primary factor affecting that public confidence in both courts and in our rule of law. I think that really one needs only look so far as, for example, President Biden's commission on the future of the Supreme Court, or the editorial pages of the New York Times, or dare I say, law professor Twitter, to understand that the ethical contours of judicial decision-making is the most pressing judicial ethics question that we face today. And yet, judicial decision-making is routinely excluded from this field of judicial ethics. Now, I think, and it's probably indisputably the case, that the reason it's excluded is largely because judicial decision-making is not amenable to judicial discipline. So oftentimes when we think of something like ethics, it's paired directly with discipline. So one of the premises of at least my talk is the idea that I think is widely accepted that ethics, and here the ethics of judging, extends beyond behaviors that are subject to discipline. So it is to an ethic of decision-making that I want to turn my attention in this lecture, because judicial decision-making is itself quite fraught with ethical complexities, paradoxes, uncertain boundaries. And here I offer a quick caveat that I know many of my fellow panelists have also said, which is simply that this subject is larger and more ambitious than can be tackled here in my short time today. So perhaps consider this to be a teaser, a preview of what I hope to address at greater length in the written work that will come out of the symposium. Mike and Rachel, at least that's my plug for the Law Review Symposium's edition. Everyone get out there next spring and buy it when it comes out. To begin with, turning back to the topic, I think we need a clear understanding of the judiciary's self-proclaimed ethical imperative for judicial decision-making. Justice Stephen Breyer, in a recent interview with the Washington Post, responded to criticisms of his court, including criticisms of his more conservative colleagues, and he did so by invoking the institutionally accepted ethical standard of decision-making. This is what he said. The single most important point is judges are not junior league politicians. They're judges. Maybe the political process worked to get them appointed, but once appointed, the judge will believe that the jurisprudence, that judge will believe that the law really requires the result. In what I think of as essentially identical fashion at the National Lawyers Convention of the Federalist Society last week, I saw it reported that the speaker kicking the convention off, who was Sixth Circuit Judge Amul Thapar, was introduced to the audience as a judge who, quote, follows the law wherever it leads, even if that means throwing nuns in jail. I think that was intended as a joke and was probably a reference to one of his decisions, but certainly embedded in that is this central ethical imperative that an ethical judge in the course of decision-making will follow the law wherever it leads. And those are just two examples among many that represent what I'll call the official piety of the judiciary when it comes to talking about what we do, what judges do. And this is true across the entire spectrum of judges and courts. Good ethical judges follow the law wherever it leads. Whatever the result may be, good judges believe in their heart of hearts that the law really requires that result. It would only be an unethical judge who would do otherwise. Therefore, it is often said, and sometimes it is often implied and sometimes said, that any criticism of judges as politicians in robes or as usurpers of the law is certainly misplaced and wrong. Now, I have to pause here and insist that you not misunderstand me. In my view, this official piety has a great deal of truth to it. It has much to recommend it. But at the same time, it is a bit more complicated than that, isn't it? I think mature, common sense people of all stripes really know this intuitively. I do find it interesting, however, how uncomfortable it often makes us to admit as much. And given that, I think we judges are sometimes reflexively defensive when it comes to these complexities. Because court after court after court will routinely reduce the ethics of judicial decision-making to this simple binary choice. Either a judge is following the law wherever it leads, or the judge is engaged in results-oriented judging that supplants the law with the judge's own preferences. And by way of example, I'll pick ever so slightly on my own court, and here are just a smattering of pronouncements on the matter from the Kansas Supreme Court. From a case called In Re, the adoption of XJA in 2007, quote, an appellate court should refrain from rewriting a plainly worded statute to simply reach a desired result. Result-oriented justice is directly contrary to the concept of the rule of law. From Leeming versus USD number 214, this is in 1988. Result-oriented justice is government of men and not of law. More recently from State v. Thomas in 2018, quote, working backwards, that is starting with a desired premise and then manipulating legal doctrine to justify that preconceived result is the very definition of result-oriented jurisprudence. And I could go on, but I'll stop there. The most important takeaway, I think, and I hope this will become more clear in a moment, is that each of these pronouncements came in a written dissent. And to be fair, I too have engaged in this sort of tisk-tisking when we write separate opinions. And so my example comes from the case of State v. Gleason in 2017, where I write and quote as well my good friend and colleague, Justice Carol Breyer, the majority leaves the impression that it starts with what it views as a palatable result and works backward to articulate a rationale. So what is really going on here? Do we judges just take turns, depending on the decision, violating our prime directive to follow the law wherever it leads? And I think we know that the answer to this is no. Something else is actually going on. And it's that something else that I think is worth exploring from within an explicitly ethical frame. At least that's the task that I've set for myself here with this lecture and paper. So let's begin with a deeper consideration of the ethical imperative to follow the law wherever it leads. And that imperative springs directly from a core character of the law itself. Here I'll quote Stanley Fish, who has observed that, quote, the law wishes to have a formal existence. That means, first of all, that the law does not wish to be absorbed by or declared subordinate to some other non-legal structure of concern. The law wishes, in a word, to be distinct, not something else. And in its distinctness, to be perspicuous. That is, it desires that the components of its autonomous existence be self-declaring and not be in need of piecing out by some supplementary discourse. This kind of formalism is in fact imprinted on the very DNA of the Western legal tradition. Formalism claims, again, in the words of Fish, that the law can be written, quote, with such precision and simplicity that its meaning leaps off the page in a way that no one, no matter what his or her situation or point of view, can ignore. And this legal clarity is supplemented by procedures that are self-executing, in the sense that their unfolding is independent of the differences between the agents, that is the judges, who might set them in motion. Thus, we can say with confidence that judicial willfulness is stopped short and obliged to press its claims within constraints that it cannot override. Another author, Hans Kelsen, put it this way, perhaps with greater purity. The law is an order. Therefore, all legal problems must be set and solved as order problems. In this way, legal theory becomes an exact structural analysis of positive law. And here's the money quote, free of all ethical, political value judgments. So to be more colloquial about this, I think it's the story of judges who are concerned exclusively with a procedural result, let's say fairness, for example. But these judges give little to no thought to the substantive outcome or the result of their decision when they apply the law to a particular case. That outcome or result is already baked into what we might call the rule of law cake. In this telling, judges are like master bakers. We meticulously follow a complex but knowable and intelligible recipe. And at the end of the day, hey, don't blame us if you don't like the cake. Blame the recipe, right? That's the formalist procedural account of the ethics of decision-making. And the fact that it appears to solve what we might call the problem of law's indeterminacy is what really gives it its rhetorical power and its lasting and seemingly unbreakable grip on the judicial imagination. Because indeterminacy in the law and the interpretive difficulties that come with it is, of course, a very real problem. And it's a problem that the formalist account claims to be able to solve. Indeed, it's true. The danger of subjective decision-making, which is predicated on little more than the personal whims or biases of a judge, is a clear and imminent danger. As I wrote recently in the case In Re FC just this year, as I tried to articulate this danger, quote, the reality of subjective judicial decisions driven by the biases of judges is a perennial problem, because that bias is nearly always exercised on behalf of the upwardly mobile, middle-class, bourgeois, and polite society from which the majority of judges come, and in which most judges continue to live. When judges are forced to choose between competing values, there will be a systemic bias in favor of the values of the upper middle professional class from which most lawyers and judges are drawn. So that's the danger, which is a very real danger, which the formalist account is designed to prevent. But of course, it has one glaring flaw. For as every judge, lawyer, and frankly, person with ordinary common sense will understand, the recipe is not as clear or complete as the formalist myth would suggest. Sometimes, in fact, grandma's notes are vague, right? Any of us who have ever made grandma's cookies probably understand this, because really, how much is a pinch of salt? Sometimes the instructions are crossed through. They may be interlineated in confusing and uncertain ways. Other times, entire sections of the recipe are simply left out. And in such circumstances, it does not seem especially comforting, or dare I say ethical, to tell people who are dissatisfied with the substantive outcome to just, quote, blame the recipe. While we can all likely agree that it is wrong for a judge to simply change the recipe based on the fact that that judge likes, let's say, chocolate cake better than carrot cake, it is unsatisfying to suggest that no master baker has an ethical responsibility for the substantive quality of the cake. In that sense, it's oddly counterintuitive, I would suggest, to say that a judge should not care one whit about the result. And further, to say that if he or she does care, that that is somehow unethical. Well, those are vexing problems, at least from the perspective of a sitting judge. They're jurisprudential problems, no doubt, and that's how they are most often discussed. But at least for our purposes and my purposes today, I think that it's important to acknowledge that, at least for the conscientious judge, and most of us are conscientious judges, these problems also have an ethical dimension. Now, it would be foolish, of course, for me to suggest any kind of easy or pat solution to this enduring and potentially unsolvable problem, but my ambition does at least extend to making an attempt to provide a helpful contour to understand the problem. And to do so, I am going to turn now to an unexpected source, the wisdom of an ancient book of Jewish law, the Babylonian Talmud, known as the Bava Metzia. And a quick side note about pronunciation, With many of these names, there's a good chance my pronunciation will be imperfect. I will do my best, but I would also be happy to be corrected by any of you who may know better. That said, the Bava Metzia is a legal tract. It mostly deals with areas of commercial law, property ownership, credit law, and the like. But it does contain one of the most fascinating and deeply perceptive fables of judging that I have ever encountered. And I want to share it with you. I think it's instructive. At the outset, it is important to give credit where it is due, and I need to note that I'm deeply indebted for this portion of the lecture to Professor Daniel Greenwood, who has done brilliant and fascinating work on the Bava Metzia and its relevance to the Western legal tradition. So my account and telling of these stories is derivative of Professor Greenwood's work, and I'll use his words interspersed with my own as I try to tell this story in a way that makes sense. This fable, which is now known as the Oven of Achnai, is the account of one particular legal decision and its aftermath. And the fable's chief character is Rabbi Eleazar, who is acknowledged throughout as the preeminent rabbi and scholar of the law of his generation. Rabbi Eleazar is depicted as a man with a brilliant mind, a man with deep virtue, and a passionate heart. He is the unquestioned authority within the council of rabbis. So, in the ordinary course of things, a legal dispute was brought before this council, which would sit as a court of final decision. Now, the question concerned a clay oven and whether the food that had been cooked in this oven was ceremonially clean or unclean. The oven, this oven of Achnai, had been broken and then repaired. And the law provided two possible rules to resolve the case. There was the rule of broken things, and there was the rule of repaired things. And the outcome of the dispute depended entirely on which rule the court would choose to apply. Thus, the case really does present the kind of dispute that lawyers and judges are quite familiar with. It's simply a choice between two rules, though, of course, the substance will feel unfamiliar to us. So continuing with the story, as the arguments are presented, the court of rabbis is divided. A majority of the rabbis take one side of the question, while the eminent Rabbi Eleazar takes the other. Rabbi Eleazar contends with all the learning, brilliance, and authority that he can muster. It is in fact recorded that he, quote, made all the arguments in the world, and yet still the court was unmoved. And it's here really that the story gets interesting, for Rabbi Eleazar's dissent takes a form that we mortal judges can only dream about. For he summons the very power of God in his defense. First, he offers miraculous signs to the council. If I am right, he declares, let this carob tree prove it. And the carob tree flies 100, or some say 400 cubits through the air. Again, Eleazar shouts, if I'm right, let the rivers prove it. And indeed, the rivers flow backwards. But the story continues, the council of the rabbis is unmoved. As a side note, I would say that's not unlike some majorities that I have encountered. This majority says, we cannot accept the legal rulings of trees and rivers. Rabbi Eleazar has one last move to play. This is his real trump card. And so he turns to the court and says, if it is as I claim, heaven itself will testify. And behold, the bat kol, which is the heavenly voice, went forth and said, why are you disputing with Rabbi Eleazar? For it is as he claims everywhere. Now, as Professor Greenwood slyly remarks, in a world of sovereign-centered positivism and formalism, surely this would end the matter. The founding father has told us exactly what he meant. Any difficulties of interpretation have been authoritatively taken off the table. All that's left for the rabbis to do here is to be good ethical decision makers. That is to say, to follow the law wherever it leads. But they don't. In fact, Rabbi Joshua, who is the leader of the majority, stands up and declares this: Torah is not in heaven. Torah was given at Sinai, and since that time we do not pay any attention to the bat coal, for it is already written, the law must incline to the majority. And the account continues that as of that day, they brought all objects that Rabbi Eleazar had declared pure, and they burned them in the fire and voted to excommunicate him from the council because he had the audacity to invoke the bat kol and thus destabilize the law. Now, the first chapter of this fable concludes with one magnificent detail. Later, another rabbi, Rabbi Natan, who had been at the council, meets with Elijah, who is often an intercessory figure between heaven and earth. And Rabbi Natan asks Elijah, what did the Holy One, that is God, do when the council rejected the bat kol? And Elijah replies, God merely smiled. And he said, my children have defeated me. My children have defeated me. Thus, this first chapter of the story encapsulates the whole paradox of text, intent, and interpretation. For it turns out, Eleazar was right all along. And yet heaven still smiled, for Torah is not in heaven. It is instead in the majority of the rabbis, even when the majority is wrong. But the story doesn't end there. The second chapter, if it was a Hollywood movie, would be titled Rabbi Eleazar Strikes Back. For he retains all of his formidable powers, and now he's really ticked. Heaven, it seems, continues to favor Eleazar, for he uses his miraculous authority to exact revenge on all those who cast him out. First, the story notes that the rabbis were fearful of even telling Eleazar the result of the court's decision because they knew that he might, quote, destroy the whole world in his anger. They were fortunate, it seems, for we're told that Eleazar only destroyed 1/3 of the olive crop, 1/3 of the wheat crop, and 1/3 of the barley crop. Additionally, the fable continues that on that great day, everything at which Rabbi Eleazar looked was burned up. Apparently, Marvel superheroes did not invent the Superman laser eyes. Rabbi Eleazar got there first. Not long thereafter, another of the presiding rabbis who was in the majority happened to be shipwrecked, and it was said that it was, quote, on account of none other than Rabbi Eleazar. The final chapter of this story, the fable of Achnai, concerns Rabbi Eleazar's death. Things have not gone so well for his students after his banishment, for while heaven had smiled on their judgment, it came at the cost of losing their father, teacher, and friend. Several of his students attended his deathbed, though, of course, they meticulously remained separated by the distance demanded by the legal ban. Still, there is some reconciliation achieved, and at his passing, the other rabbis cry out, woe unto me, my master, because of thee. Woe unto me, my teacher, because of you. For you have left the whole generation fatherless. And then we are given one last scene. Rabbi Eleazar now sits among the firmament after his death, discussing, what else? The Torah, with none other than Moses and the Holy One, as Rabbi Eleazar instructs them on the finer points of the law. So who in the end gets the last laugh here? Who was ultimately vindicated? We want to know. Framing it in the terms of this talk, who was the ethical decision maker? The Bava Metzia denies us the satisfaction of an answer to these questions. For the fable of Achnai is filled with paradox and misdirection. And that, of course, is the point. For while this is a fable about many things, it is principally about the paradoxes of decision making. In the end, the oven of Achnai is a powerful exercise in myth making. And here, in the interest of time, I will conclude these remarks with the words of Professor Greenwood. Quote, Achnai shows both the attraction and the importance of the traditional answer, both excluding it in favor of the current majority and condemning the majority for that exclusion. The very authorization of majority rule reminds us that the majority is not authorized to do wrong. The very act by which the majority asserts its right to rule is simultaneously accepted as an act of the majority and criticized as wrong. Even a majority entitled to make the rules is not entitled to dishonor and exclude its minority members. Law is a communal experience, Greenwood continues, without a fixed or predictable result. Achnai stands for the power of paradox over coherence, wisdom over logic. Achnai is a part of a battle to define the limits of civilized discourse. Invocation of absolute truth is incompatible with continued debate. Achnai chooses discussion over truth, living together over correctness. And yet, Eleazar, like the tradition for which he stands, remains attractive and important, even if he must be excluded. For in rejecting him, the rabbis deny Eleazar and the truth, the respect that he and it rightly demand, thus contradicting the principle that entitles them to exclude him. In so doing, they have left an entire generation without its teacher and father. And finally, my words now, the fable of Achnai opens up for us the terrifying reality that for a court, a judge, and even for a political community that is in the throes of an especially difficult decision, heaven smiles mischievously down at us, for indeed the Torah is not in heaven. Thank you.
Thank you, Justice Stegall. It was excellent to have you on our panel today as our keynote speaker, and we look forward to your article. And again, the symposium edition of the Kansas Law Review will be posted, or will be published in the spring of 2022, so that is coming up. In the meantime, we will move on to our question and answer session. So Professor Michael Hoeflick will go through the questions that we've had. If anyone has additional questions, please enter them into the Q&A now. Thank you so much.
Thank you, Rachel. I appreciate it. And thank you to all of the panelists. I have to say two quick things before I get to the questions. Number one, I was fascinated by Professor Arians' history. And I should mention that in Roman law, it was considered unethical were a judge to ask one of the litigants to sit by his side on the bench. How's that for appearance? And then secondly, I have to thank Justice Stegall for his wonderful talk and for his discussion of Baba Metzia. I spent many, many hours as a teenager studying Talmud, reading Baba Metzia and of the adventures of Rabbi Eleazar. And yes, you pronounced them very well. At the moment, we have two questions. I'm going to ask any and all of the panelists to please jump in and answer either or both of these and any others we get. The first is directed to Professor Davies specifically, and this is from Harold Vanderson, and he says, is it the opinion of Professor Davies that the tools used to manipulate the Supreme Court are necessary in our form of government, or do they only serve to undermine the public's view of impartiality of the court? Professor Davies, you start, and then anyone else who'd like to jump in, do so.
Thank you, Professor Hoeflick. I guess my opinion is that no particular tool is necessary, and that nevertheless, institutional interests will want to influence and will seek to influence the membership of the court, as well as the decisions it makes. And so I think what we probably can safely say is that the phenomena of attempts to influence the membership of the court are with us forever and are part of government. To the extent that they are abused or used in ways that are sort of inconsistent with norms of ethics and process, yes, they could indeed undermine public confidence in the court. And I think that's part of what makes the efforts of the justices to deal with Justice Douglas's incapacity troubling, is that it's one thing to do these things in secret. It's another thing to do them under the bright, clear light of day. And that is one of the things that I suspect, never having sat on a bench except a moot bench, that judges inevitably struggle with, is how to help their colleagues do the right thing in terms of choosing when to go.
Would any of the other panelists like to jump in at that stage and comment? Please just go ahead, turn on your microphones and do so. I think, Ross, you answered it and everybody is impressed. The second question I've got is from Colin O'Donnell. Justice Stegall, is the inherent leaning toward the upper class a solvable problem within the court, or is it simply a bias that each justice should be aware of?
Great question. And whenever a judge starts an answer to one of your questions with great question, you know that maybe there's a dodge coming. So I'll try not to dodge it entirely. I would just say that certainly self-awareness is a very important first step, because as I mentioned, in my experience with many judges, we're conscientious. Judges want to do a good job. They want to be ethical, even when there's no threat of discipline, that is in the decision-making process. So awareness is a big part of that. The second part of my answer, I think, would be that whenever the choice of legal rules that courts either choose for themselves or perhaps have chosen for them in the form of legislation, whenever those rules fail to present objective, measurable standards, judges are in a real quandary, oftentimes having to fill in the blanks ourselves. And that's when the subjective experiences, et cetera, of judges are at least threatened to be brought forward into the decision of the court. So really, I think most judges would say, hey, we really rely on and greatly desire objective, measurable standards and rules that we can apply using the traditional tools and skills of the legal profession. That is what protects primarily against those kinds of biases.
Thank you, Justice Stegall. I have one other question from Meredith Wiggins. I'd love to hear from the panelists about any points the other panelists made that you think could enrich the analysis offered in your own talk or article, or offer directions for future work. It's open to anybody on the panel.
Well, I'll cheat and say that my neighbor down the hall gave an extremely, I think, useful and provocative discussion of the appearance of propriety that I think not only reads as many of the strengths of Professor Courtney's leadership question, which underlies and threads through most of what she was doing, but it is critical for all of us, because there's no way the appearance of impropriety can be limited only to manners and behaviors while on the bench or off the bench. The types of impropriety that were at play in the example he brings up of Judge Landis are trivial compared to the types of impropriety of judges that refuse to grasp that paradox. I was taking tons of notes while Justice Stegall spoke, and I am very eager to be my own bargain basement rabbi, trying to figure out how to apply not only the obvious lessons of the Talmud, but the approach that he's taken to not committing in the way he has this paradox to any particular resolution, to try and find how we can resolve exactly this paradox. So I'm very grateful to all of you.
Thank you, Professor Shepard. Other panelists, please.
Yes, and sure. And I just also want to thank all the other panelists. I'm inspired. I appreciated the historical perspective. And I also will tell Professor Greenwood, with whom I used to teach, that he was part of this. I think he'll be most appreciative of his being a part of it. I wanted to thank also a fellow Texan now, Dean Shepard, Professor Shepard, because I thought his questions were particularly interesting. And from the standpoint of my own article for the KU Law Review, I'm going to look at his formulation of the leadership question, because I thought that was particularly insightful in terms of capturing the role of a leader and, what is sometimes called a servant leader. So thank you, Stephen, for that inspiration as well.
Thank you, Professor Fortney. Anyone else would like to jump in?
Michael, if I may, a big part of the justice's own role in regulating each other has to do with one of the things that Justice Stegall emphasized, which is self-awareness. And I think I need to do more with that in that part of my paper, based in part on what he said. And one of the things it prompted was a little more thinking, even just during the time we've been here together, about the value of a multi-member diverse bench. Judges are to some extent, just because of the natures of their jobs, isolated from the rest of us in some ways. And having good colleagues who talk to you about these things is probably pretty important. And I do wonder whether part of the struggles at the US Supreme Court has to do with what Oliver Wendell Holmes called the 9 scorpions in a bottle syndrome, which is if you are in fact 9 individual law firms operating in isolation as opposed to a collaborative group, you lose touch, the routine contact, the communication about when you're behaving right, when you're behaving wrong, when you're thinking right, when you're thinking things through from multiple perspectives. So it was a valuable point by Justice Stegall. I thank him for that.
Thank you, Professor Davies. Professor Arians, I believe you wanted to say something.
I do. I am absolutely ready to start rethinking my paper just by listening to Steve's talk, Justice Stegall's talk, and Susan's talk as well. They forced me to think a little bit more about how the notions of leadership can affect the way in which one thinks about why appearance may be more important than I initially gave credit to. And Ross's history was quite fun, and I'll be able to use it a little bit more in my constitutional law class as well.
Good, thank you. I believe, okay. Professor Shepard actually has a question for Justice Stegall. I guess that's allowed. Does the paradox of judgment make essential a realm of discretion in each judgment, in which the law neither clearly requires nor clearly forbids a range of possible answers? Caleb, we can't hear you. I think you need to turn on your mic.
You're right, I do. Sorry about that. Thank you, several of you, for your kind comments. It's great to be part of a panel like this, and I do really look forward to our mutual work together to put the symposium issue together. As to the direct question, I think the answer has to be yes. I mean, that's the easy place to start. It gets a lot more difficult very quickly as soon as you sort of interrogate that yes and say, well, what do you really mean? What are the contours of that discretion? I think, and there's no way for me to do justice in just a few minutes to that question, but a few quick thoughts that occur to me off the cuff. First, as I think referenced by another panelist, the value of a multi-member court is indispensable to the functioning of to the good functioning of especially an appellate court of last resort, like the court that I sit on, and certainly like the United States Supreme Court. That collegial professional environment in which very important ideas can be contended with, and often that contending can be, as in the story that I've related, quite significant. But at the end of the day, there has to be a recognition by a majority that it may be wrong, and it needs the minority, and it cannot ever exile the minority from its membership. So that dynamic goes a long way to cabining what I think we're actually asking about, which is that realm of discretion. And certainly that exists. In some kinds of cases, there's a much wider realm of discretion than in other kinds of cases. And of course, courts and law professors and lawyers work very hard in conjunction, I would say, with the general public to understand and describe coherent rules that will that are sort of the rules of the road for judging, and help everyone in the political society understand not only what a court is doing, but whether or not it's acting, as I've tried to describe, in an ethical way in its decision-making process. I hope that at least scratches the surface of your question. It's a great question.
Thank you. Well, we've just got a few minutes left, and we have no more questions that have come in. I'll turn this over to Rachel Zierden in 1 second. I want to finish by saying two things. One, I have always admired judges, and in part because in my 40-some years as a law professor, I have cherished the ability to be able to answer questions that are put to me with a statement, "I don't know." Judges, unfortunately, don't have that freedom. And all that Justice Stegall was saying made me think about that very, very strongly again, that you have to answer when you're a judge. When you're a law professor, you just say, "Nope, I don't know how. I don't know what the answer is. We'll leave that to the judges." Judges, alas, can't do that. I want to thank all of you, those of you who spoke, those of you who listened, and those of you who've attended, for coming to make, I think, a wonderful symposium. To me, the mark of a good symposium is when people talk to each other and people are influenced by each other. And I think that's going on right now. And that, to me, is the whole purpose of this kind of thing. So with that, let me turn it over to our symposium leader, I'll use that phrase, as well as editor. Rachel, you're on. You can have the last words.
Excellent. Thank you so much. First and foremost, I just want to say thank you to the audience for your thoughtful questions. And I would like to take this time to thank the panelists for their participation. They are extremely busy people, as you all know, and they took time away just to teach us more about judicial conduct. So we cannot be more appreciative. Thank you so much, panelists, for your time. I would also like to thank my faculty advisor, Professor Michael Hoeflick, for his effort and dedication towards creating this symposium. I could not have done it without you, Professor, so thank you so much for all your time. And last but not least, I would like to thank Margaret Hare, Rebecca Clayton, and the marketing team at KU Law for working so hard to make this symposium a reality. I also could not have done it without you all, so thank you so much for your hard work. And with that, that is the end of our Fall 2021 Kansas Law Review Symposium. Thank you all for attending and listening, and we look forward to publishing the symposium edition of the Kansas Law Review in the spring. Thank you so much.